Welcome to the Arrive U.S. Immigration Law podcast with your hosts Jeremy Richards and Christine Jerusik. Join us as we navigate the complex world of U.S. immigration law with a special focus on opportunities and challenges for Canadians and Mexicans under the USMCA. Whether you're a professional, business owner, or family member seeking to work and live in the United States, we're here to guide you every step of the way. So sit back and relax. You have arrived.
Welcome back to another episode of the Arrive podcast, where we talk about U.S. immigration law for Canadians. So today, we are going to be discussing some family-based immigration scenarios, specifically for family sponsorship and whether or not you should process your case. And I'm going to simplify it, and then we'll get into the weeds a little bit. Should you process your case inside the United States, or should you process it in Canada? And what makes most sense? And
some Canadians might understand this better in the terminology of Canada. It's inbound versus an outbound application. Here in the United States, we have them considered as inbound being adjustment of status and outbound being consular processing.
And consular processing, if you've followed us at all, is done in Montreal, Canada. That's the consular processes all outbound cases to the United States. The consular processing is what they're referred to as. They're all processed there. So it doesn't matter if you're in, and I'm looking at a map right now, if you're in Dawson, Canada, never heard of it, way up there by Alaska, guess what? You got to travel all the way over to Montreal. Or if you're in Shefferville, you've got to go to Montreal. So it doesn't matter where you're at, Vancouver, you're going to Montreal. That's where they process your case if you're in Canada. So that's something, travel's one thing to consider in that process. And if you're in the United States, on the consular processing, before I jump to the next one, if you're processing outbound consular processing, you deal with 3 agencies. And I think that's something very important to understand when you're doing consular processing case.
Should we go over just briefly what each of these options is, and then we can get into the details of what the pros and cons of each one?
Yeah. So consular processing, you're dealing with 3 agencies, right? You start your filing with what is called U.S. Citizenship and Immigration Services, and it's all initiated with a filing of an I-130 petition.
So that's where your U.S. citizen or permanent resident relative sponsors you through an application filed with the Immigration Services here in the United States.
So it's, which is funny, you're in Canada, but you're initiating your case by filing in the U.S.
Well, if you're an American citizen or permanent resident, then that's how you start it. You file it with the authority that's going to make a decision on whether or not.
But they're not the ultimate say, right? So you start with them. Mm-hmm. Once they adjudicate and approve it, then it's sent to another agency.
Right. And what they're looking for in that initial one, in adjudicating and approving that, is your relationship, right? Is
it bona fide? Is it real?
Are you a mother-daughter? Are you a father-son? Are you a spouse? Are you a, whatever
qualifying
it is,
relative.
Sister, brother, whatever it is? Okay.
Yeah, you're a qualifying relative that deserves approval of an I-130 and then family-based sponsorship, right?
And right now, that's taking around over a year for them to make decisions on those cases.
And that's all done with USCIS in the United States.
Right.
They approve it. And if you look at the approval notice, it says they have 6 to 8 weeks, we'll forward this approval to the National Visa Center. And the National Visa Center is department number 2 that you're going to be dealing with within U.S. immigration. Mm-hmm. And another agency. So you have 2 agencies you're working with here. USCIS has already done their work, and now National Visa Center steps in.
They get to make their decision.
In the National Visa Center, just so you understand what their part of this process is, all I-130 approvals that are for consular processing go to the National Visa Center, and the National Visa Center's job is then to coordinate with the appropriate consulate to then schedule an interview.
And
so they deal with cases all over the world. They're not just dealing with Canadians.
Right.
So everybody's I-130 has to go to the National Visa Center. Then the National Visa Center will coordinate once you meet their requirements, you're going to have to do a lot of it seems like you're doing a lot of stuff over again, because you are at the National Visa Center. You're like, wait, didn't I already prove all this stuff? Didn't I already submit all this stuff? The answer is yes. They do ask
it's like, you already have my marriage certificate. I already sent it to you. Okay, but they don't have it.
Yes.
USCIS has it. Now the National Visa Center is part of the Department of State, a completely separate agency from USCIS.
Yep.
So,
And
I mean,
gonna
it's
do
all under
document
Department of
verification.
Homeland Security, but I don't think they talk to each other. So
They don't talk very well. So it's just it's another step in the process. And everyone throughout the world, once your R-130 is approved, if you're consular processing, you got to go through the National Visa Center. And they're going to do their checks and balances, request your documents and information. And then once they're satisfied with your submission to the National Visa Center, they will then give their stamp of approval, which is called, they're going to then your case will become documentarily qualified, which means you gave them everything they need. Now, the National Visa Center will then notify the consulate, in this case, Montreal, hey, we've got everything for this case. Let us know when you have an available interview. And then Montreal will then let the National Visa Center when an interview is available. And then National Visa Center will say, hey, you've got an interview scheduled with Montreal. So they're the middleman to get you your interview with Montreal. Then you'll get a notification of interview. And at that point, then you would have to satisfy that interview notice. Make sure you bring, again, a lot of the same documents all over again. At this point, you have to get a medical exam too prior to that consular processing interview. And then you would then ultimately go to Montreal, where they will conduct that in-person interview. And this is important
with just the intending immigrant. So your family member, your U.S. permanent resident or citizen family member doesn't need to be there. In fact, they're not invited
allowed
to the interview.
Yeah.
So you need to go by yourself and have that interview on your own as the intending immigrant.
And at that point, they will then make a final determination. So you have to essentially go through 3 approvals.
They may make a final determination, or they could leave you sitting there and holding on with administrative processing.
A lot of
that's
uncertainty.
What they decide to do. Yeah.
So that's consular processing, and we'll start comparing these back and forth. But that's consular processing.
We're going to do pros and cons after.
Yeah. So that's consular processing. Okay, you're in Canada. You want to process through Montreal. Once you're approved, then you would come into the United States.
Right.
Those are the agencies. Those are that's the simplification.
So they make the decision in Montreal, and there's another step after that. Now you have to come. You don't get your green card. You get a visa.
You get an immigrant
visa to enter the United States, and then you come to the U.S. You process at the border, and then they will mail your green card to your U.S. address. So there is that extra step after the interview in order to get the green card. I think you also have to pay the immigrant fee.
Yep, you have
to
6 months to enter on that immigrant visa typically. It could be shorter, so you got to pay attention. And then you have to then pay an additional fee, notify the border. At the border, you will notify them that you are coming in on your immigrant visa with intent to move to the U.S., and that signals then the production of your actual green card. And that's the ultimate thing that you want here. And then that green card will then show up in a couple months at the U.S. address that you provide.
Right. So we also refer to this type of application as a 2-step application. It's really multiple steps, but as a 2-step application because there is the filing of the petition and the approval of the petition, then the consular part of the process where you file with the consulate, and then you have to go to an interview and get approved by them as well. So 2-step application or consular processing. That's one option.
Yeah, so if you ever hear of the 2-step process in immigration parlance,
family
that's
immigration,
what that means. Yeah. Your consular processing.
Yep. So, but there is another option for certain people in certain situations to file for what's called adjustment of status, or a 1-step application, where you file everything all together with one agency, and they process the whole application start to finish. They conduct the interview, and you're not back and forth with these other agencies. It can be faster in some instances to do it this way. So that's kind of a pro, I guess, of doing the 1-step adjustment of status application. But it's just another option. But the only way you can do it is if you're already in the United States. So you can't file to adjust status if you're outside the United States, hence the term inbound, right? You're inside the U.S. already, and you're there with your U.S. citizen or permanent resident family member, and you file to adjust your status from whatever status you're in, visitor, TN visa holder,
L1,
student, L1 holder,
E,
to permanent
whatever.
resident of the United States. Yeah.
Yeah. So there's two terms you need to understand. One's called change of status, and one's called adjustment of status that we're referring to. A change of status is when you go from one non-immigrant visa or a temporary visa to another. So let's say you go from visitor to a TN, or from a student to an H-1B. You're changing between temporary visa statuses. That's what's called a change of status. Adjustment is when you go from a non-immigrant temporary visa to a permanent status, a green card. You're adjusting to become a permanent status here in the United States. So one agency, and I think that's the biggest advantage of adjustment of status. And typically, adjustment of status case that we're seeing nowadays, they're being adjudicated from filing in less than 12 months, sometimes much less than 12 months. So if you compare that to consular processing alone, well, consular processing, the first step typically takes at least 12 months. And then you add on the second, and then the third step, well, you could be well over 2 years by the time you get your interview. Whereas adjustment of status, all done one-step filing with USCIS, which leads to often quicker adjudications because you're only dealing with one agency instead of multiple different agencies, and really a redundant process. So USCIS is if you are in the United States or can get here and can stay here, is the way I usually put it,
right.
and don't have to travel or work while you're waiting.
Yep.
We're going to recommend that the majority of the time. And some people have that advantage where they could come in as a Canadian. Maybe they find themselves here for Thanksgiving and they decide, you know what, I can't go back to Canada. I need to stay here with whoever your loved one is. And if the situation is right, and there's some factors into this, spouse, it's easier to stay here, or a parent of a U.S. citizen because they're not subject to visa backlogs. Siblings, it's a little more difficult. You could have decades of waiting before you could do something like this. But if you find yourself in legal status and you're in the right category, you could file the paperwork to stay in the United States without having to return to Canada through this one-step process.
Yep. So I put together a quick pros and cons list of each of these options
Let's do it.
that we can go over. So, and looking at it's heavily weighted towards one side, and just keep in mind, everybody's life is different, right? So even though I'm listing these as pros, it might be a con for you, right? Maybe you don't want to work in the United States while you're waiting for this process. But the biggest one, and I think the one that most people make their decision on the basis of, is the ability to travel internationally. Okay. So that is a big pro for consular processing. While you're going through that process, you're going to continue to be able to travel using your passport to whatever countries in the world you want to go to.
Even the U.S.
Even the U.S. You can visit the U.S. while you're going through this process. If you're going through and you choose the one-step adjustment of status process, international travel is going to be curtailed for some time. You're going to be stuck, and I say stuck in the United States. Most countries and nationalities around the world aren't concerned about being stuck in the U.S., but Canadians generally, we don't love it. So we like to,
they have
we
to,
like to be
especially in
able
the
to
winter.
go home. Yeah, I mean, no, in the summer we want to go home to Canada in the summer, or for the holidays.
For winter, they want to get out and get down to the Florida.
Right. So that is a big pro for consular processing and a big con for adjustment of status. And that sometimes is the only factor upon which people make their decision.
Yep.
I cannot not go back to Canada for a year. I have to be able to go see my kids, my grandkids, my parents, whatever it is. I must be able
Maybe
to
for
travel.
work or whatever.
If that is the case, then your only option is to consular process, because everybody who participates in the adjustment of status process is going to be spending time in the U.S. where they're not going to be able to travel internationally. Okay, so that's the big one. That one right out of that.
When I am talking to people through a consultation and they're making that decision between consular processing and adjustment, it's that exact conversation. Can you sit tight in the U.S. without the ability to travel internationally or working?
Right. And for the most part, these people are already here And if they've already been here for a while, they've already made their decision. Yeah, the reason we're doing this is because we don't want to be separated, right? It's really hard to start out in a marriage relationship and be separated for a year. That's tough.
Yep.
Even if you can visit each other, not starting your life together can be hard. So if you're here, you're married to a U.S. citizen, adjustment of status and that travel restriction may not be a big deal to you. It might be the best option for you.
And it's ultimately faster.
All right. The other thing, let's bring me to the second point, timing, right? So consular processing, start to finish at the moment.
Well, right now, Montreal apparently cleared out their backlogs, so they're caught up. And apparently documentary qualification through MVC is taking less than a month. And then interview shortly thereafter. So we're back. It looks like we're back to 18 to 24 month processing, but that changes all the time. Mm-hmm. So safely, I tell people 2 to 3 years.
2 to 3 years for consular processing.
I think that's a conservative one. Can it be faster? Yes, you have anomalies, and it all depends on what's going on politically with interviews and everything like that.
Or specifically within your case, if you have any complicating factors that could prolong the documentation qualification side of it.
And you brought up a very, very important part of consular processing. That if they have an issue with your documents or your travel, your immigration history, your criminal history, you have an added component with consular processing where, let's say you had a DUI in your record in the past, or maybe drug abuse, or whatever it was. Depending on what it is, it could automatically disqualify you. But let's assume it doesn't. You could, if you have a DUI on your record, they could tell you to go to what is called a panel physician. And this is in addition to the standard medical that you have to go through before you even get this interview. And that panel physician will then do some blood work and tests to determine whether or not you're what they call a habitual drunkard before they can approve your case, which could add weeks to months after your interview to make a decision. Or let's say you've traveled to certain countries, or let's say you maybe worked unauthorized in the U.S. or had some other complicating factor, or maybe they just want to look more into your history for some reason. They can put you in what's called administrative processing.
Right. So that's a complicating factor with consular processing. If you're put into administrative processing and your case isn't processed in a normal timeline, now you are a family member who's not with your U.S. citizen, spouse, partner, family member. You're stuck outside the country, right? Without having access to that immigrant visa because of whatever complicating factor you had. Where if you had adjusted status, you would be in the U.S. with your family member, which is where you're trying to get to, right? Ultimately, you would be stuck in the U.S. just waiting for that decision. So you have to figure out which one's going to be better for you on that basis. So the timing factor, like Jeremy said, possibly 2 years,
you maybe even 3. Process or administrative processing, it could be even longer because administrative processing, they don't even have to get back to you for at least 180 days after your interview.
Yeah.
That's another 6 months.
We kind of consider it a black hole sometimes because I've heard of people being in administrative processing for years.
Yep.
So sometimes people go through the whole consular processing route and then they end up adjusting status anyway because the consulate never makes a decision on their case.
They end up finding themselves in the U.S. and say, you know what, can I stay? And then we file adjustment for them.
Adjust status, yeah. Okay, so timing on adjustment of status right now, locally we're seeing it
6 to 12 months
for spouses.
Yeah.
But it can be even faster in some places. Sometimes it takes longer. I usually tell people to bank on about a year.
I always say a year to be conservative because typically it doesn't take longer than that. It can.
Yeah.
But
in some jurisdictions, it takes a little bit longer. I think I checked recently. I think it was in Texas somewhere. It was
California.
It was pretty backlogged. Yeah. But at the same time, checking those timelines, those change every month. So even if you're told, hey, it's going to be 27 months, sometimes we see people get decisions a lot faster.
And you'll get the random case that processes in 3 months.
Right. So timing wise, I say adjustment of status, that's a pro and that's a con for consular processing.
Oh yeah, it's easily twice as fast.
Yeah.
If not 3 times as fast.
Yeah. And an immigration attorney can help you kind of hammer down those timelines a little bit more accurately depending on where you are and how that local field office is processing cases. But they can only do so much because it changes every month, so you never know.
I mean, I've had clients process in California, New York, Pennsylvania, all over the country recently, and not one of them's taken over 6 months.
Yeah.
Not one.
Which brings me to my next point, pro and con. You're dealing with one agency when you're working with adjustment of status, okay? One agency, USCIS, that's it. When you're working in consular processing, as we talked about, it's two agencies and then two different departments in one agency, the Department of State, the National Visa Center, and the actual consulate.
Well, you can throw the fourth because then you still got to go to the border.
True. Yeah. That's
right?
Usually kind of a pro forma interview.
But you could get it all the way to the border and the border could say no.
Yes.
They have the ultimate say.
True. So I think that's a pro then for adjustment of status, one agency versus multiple agencies for consular processing.
And on the work note for adjustment of status, you can file for work authorization at the time you file for your green card. So even if it does take a little bit, you could potentially work while you wait.
Good point. So another pro for adjustment of status, work authorization will be issued in most cases, usually about 4 to 6 months after filing.
But the way things are processing now, you get your green card anyway.
Green card faster. With consular processing, you do not have the opportunity to get work authorization in the U.S. while you're waiting. You can continue to work in your home country, Canada. You can keep working there and living there while you're going through the process. And, if you're not willing to give up your life in Canada until you have that green card in your hand, consular processing may make sense. But one of the pros, I would say, for adjustment of status is work authorization availability.
Yep.
Which brings me to, again, my next point, forgiveness of sins. So if you are the spouse of a U.S. citizen, with adjustment of status, and you come into the United States and you've been here for a while and maybe you overstayed your visitor visa, but you got married or you are already married, you can still file and get your green card and they'll forgive that overstay from your last entry. Keep in mind, it's only for certain people, spouses, parents of U.S. citizens. It doesn't apply to family members of green card holders. Also applies to children of U.S. citizens under the age of 21. Anybody over the age of 21 is not going to get that same forgiveness, but if you're a child of a U.S. citizen, and it's not just that overstay, it's also any unauthorized employment. So if you came into the United States as a visitor and you worked without authorization and you disclose that on your green card application, in certain instances, that's not going to prevent you from getting your green card. So I think that's a pro with adjustment of status too.
Yes, a definite pro.
Yep.
Whereas you disclose that at consular processing.
If that comes up in your consular processing that you did those things,
you won't get the same forgiveness. You could be subject to a ban and have to get a waiver.
Yep. You could need a waiver, which is a whole nother years-long process.
You overstay
to get
by
that immigrant
6 months
visa.
or more.
Yep.
You could get a 3-year bar.
Yep. So
a year or more, a 10-year bar.
So the important thing to do is if you're here and you've done any of those things and you're married to a U.S. citizen, or if you have a U.S. citizen, talk to a lawyer before you leave.
Yeah. Because leaving is what triggers that bar. So if you're here, it won't be triggered. But if you leave and it'll trigger it. You go to the consulate, you go to an interview.
Yes.
You were here, then all of a sudden you're subject to a bar on the entry to the U.S. and you need an immigrant waiver. So your life can become much more complicated.
Right. So another pro for adjustment of status.
Absolutely.
And then what did I write here? I can't even read my handwriting.
Don't ask me to read
consular processing. You're separated from your family member while you're doing this process. You can come and visit, but you're separated. You're living two separate lives. You need to maintain your life in your home country while you're going through it. But with adjustment of status, you're together. You're together in the U.S., regardless of how long and complicated the situation is. You're still together. Yeah. So that's a big upside.
And you don't have the uncertainty of, because even though in most cases you can continue to travel back and forth with this pending, that's at the discretion of the border. So you could get a border officer says, you know what, I understand, but you're not coming back until that green card or until that immigrant visa is approved. Stay in Canada.
Sure. And I mean, I think Jeremy's also talking about advanced parole here, which is something, and I just had a client ask me about it yesterday. What about this advanced parole thing? If I'm adjusting status and I'm stuck here in the United States, if I get advanced parole, then I can go back home and I can go see my family and do what I need to do. That's the way it's supposed to work. But in reality, advance parole isn't something that's meant for you to do recreational travel outside the country. It's for emergency situations. And even getting it approved in this current climate, advance parole is what it sounds like. It's parole. So somebody needs to permit you and parole you into the United States. It's a lot of discretion.
And it doesn't give you status, right? So
yep.
You're just coming in under their discretion.
It's discretion of the border officer to admit you. And
Do
if they
you
decide,
want to be subject to the border's discretion after you leave and coming back in?
Right. And it's not just your ability to be in the United States that's at the discretion, because if they deny you entry to the United States on your advance parole,
you gotta start
then
the
your
process
green card
all over
application
again.
will be denied for abandonment, and you will get to start the process all over again outside the country, and you will be going through that consular processing route that you chose not to start with. So
yeah, we tell people, my advice to people typically is, unless the sky is falling and you have no other option, don't leave the U.S. Stay. There's very limited situations where you would absolutely need to travel. And unless it falls into one of those emergency humanitarian situations, do not leave. Don't go for Thanksgiving, or don't go for, because you have to go to a seminar for work or whatever.
Stick it out a few more months, get your green card, and then enjoy your worry-free travel home.
I wouldn't. Yeah. And it says it right on advance parole document too. It does not guarantee reentry.
Yeah.
It warns you on the document.
Right. So
you leave, you may not be coming back.
I know a lot of our Canadian clients think, I got advance parole and I can just use that to go home for Christmas or whatever. You want to be careful with that. We're advising our clients presently to not travel on that unless absolutely necessary.
Yep. And so stay home.
Yeah. Any case examples you want to talk about that speak to any of these situations? I have one I can.
Yeah, I've got one too. We can talk about yours first.
So I had a couple, and they weren't Canadian. They were a U.S. citizen wife and a husband from Bangladesh, and they filed adjustment of status, and they were going through the process. Everything was going very smoothly, but his mother became ill, and so he wanted to travel, had not received advance parole yet, was not approved, didn't have time. So he thought to file for emergency advance parole. So he left the country against our advice, against his wife's wishes, in the middle of his adjustment of status application. And this happened probably 2 years ago. He's still not back here. So he since he left the country, his case was denied for abandonment because he left the United States and before he had received his advance parole. The application the 485 was denied, and now he is pursuing consular processing with the consulate in Bangladesh. And that poor guy and his wife have been separated for many years because of that decision that he made, that rash decision he made against our advice. So you got to be careful if you're in the midst of the process and an emergency arises or something comes up. Just talk to your lawyer first before you, book that ticket, because you could be really causing yourself a lot of headaches down the road.
Yeah, I've had that. I've had it happen a few times. I had a client. He was going through adjustment, and this one flew to Brazil and then was coming back to the U.S. And he emailed me for some reason. He's like, "Hey, how do I come back to the U.S.?" And I said, "Wait, what? Come back to the U.S.? You left? You were not supposed to leave." And fortunately, he had 2 passports. I forget what his other citizenship was. I think it was Brazil and Portugal or something. Anyway, so he re-entered on another passport somehow.
No.
And then his adjustment, it was not just him. It was him, his spouse, and 3 kids abandoned.
Oh, no.
So then we had to then refile everything. You're talking thousands of dollars in fees to refile because he went on this work trip. We were able to save the case. He was able to luckily re-enter. In most cases, you're not re-entering.
Right.
But he re-entered, and we had to refile all of the paperwork from scratch.
Wow.
And restart the process. Again. Got their green cards, but at a significant cost because we had to refile everything.
Yeah.
Had another one, and this was a local one. They were here and actually, cross-border from Niagara Falls, Canada, Niagara Falls, U.S. The wife just couldn't sit tight. Filed her adjustment. She's like, "Oh, I got to go back to see my mom or whatever." I'm like, no, you can't. You don't have advanced parole.
And just to be clear, nobody's going to stop you from leaving the United States. So there's no warning that's going to pop up and Canada's going to turn you around.
Oh, they'll let you in.
They'll let you in. You can leave. You can travel. Nobody's going to
Coming back
stop
to
you.
the US.
But the problem is re-entering the United States, right? So now you can't come back.
So she left, abandoned her case.
Oh, man.
And again, same scenario. Well, this one was different because the other individual I was talking about was able to re-enter the U.S. and then continue with adjustments.
Yes.
So they were great there. Nope, not her. She went back to Canada, abandoned the case, and then had to go through consular processing.
Yeah, and
from scratch.
Right. And so it's not like you can just switch to consular processing when your case has been filed for adjustment of status. There's an extra step in there that if you do that, you then need to file an application.
That's if they don't revoke the I-130.
Which they could, and then you need to start the whole thing all over again.
And that's actually faster. So what you're talking about is you have to, it's a decision on an approved application. So you have to notify USCIS that you no longer want to adjust, but you want a consular process. The processing on that is 18 to 24 months.
No.
Yes.
Last time I checked, I thought it was like 6 to 12.
They sped it up.
Oh,
well,
maybe.
In any event, it's not quick.
No, it's not.
So
it adds,
most of the time
could add a year to your processing. So let's be honest.
Sometimes it's just quicker just to file an I-130 all over again because getting it transferred to the consulate is going to take longer than it would to file a new case.
Yeah, just withdraw the old one and file a new one.
Yeah, it's so.
But anyway,
don't do that.
That screws up your case. So,
and I just right before this podcast, I actually was speaking to a client.
Yeah,
and it fits right into our conversation. His wife had filed, and this is a Canadian, and they're actually here locally in the Buffalo area. And his wife's a U.S. citizen, filed the I-130 petition. It was approved for consular processing.
Nice.
So he's pending processing in Montreal. He's in the U.S. So he's like, I want to.
He's visiting the
U.S.
Okay.
He's like, I don't want to go back. I don't want to wait for this consular thing. They've been waiting. Oh gosh, I think 2024 is when he was documentarily qualified. So he's been waiting a long time to get his interview in Montreal. And he said, I'm going to adjust. Can I do that? And I said, yeah, we can help you out. Let's adjust. You're in the U.S. legally now. You're married to a U.S. citizen. The I-130 is approved. We can do the adjustment paperwork. Within the last, actually 2 days, was it yesterday? It was either yesterday or the day before. He got notification from Montreal.
Oh, you got his interview.
Because they just cleared out all this backlog.
Yeah.
Oh, your interview's up. And it's going to be in January. So now they have a decision. Are we going to consular process? Or since I'm in the U.S., and there's certainty in that. And that's where I'm going here. There's certainty that he's in the U.S. right now. He knows if they file right now, he's going to be in the U.S.
He's going to be able to wait.
He's going to be able to wait in the U.S. They're going to be together.
Right.
Now, however, if you decide to go back to Montreal, there's uncertainty of when he will return. Well, now why? Well, there's a lot of factors outside of your control when you leave the United States. One is the consular processing. They do background checks. They do, they look into your history. If you get put in administrative processing, which is a high rate these days, you could be stuck in Canada for who knows how long before you come back.
Yep.
Right? Even then, you got to go to the border, and the border has to readmit you, right? So you have all of these factors outside of your control. Whereas when you're in the U.S., you're just dealing with that one agency. So now the decision is, do I just want to play it safe and stay in the U.S. because I'm already here? Or should I go to this interview?
Faster route and go to the interview.
Because if everything goes smoothly, it'll be faster. Because January, you're not going to get a case processed faster than January.
Yeah, but I think that what we need to do is find out what complicating factors he has in his background that could possibly put him into admin processing.
Yeah, so if you go into a background of somebody and there may be a criminal or immigration violation or anything at all, or visiting certain countries, your risk of consular process or administrative processing is high.
Yeah. I mean, even without those complicating factors, I've had people.
It's a gamble.
I had a couple, and they were filed a fiance visa.
Huh.
They didn't.
Worst visa
they don't
in the
consult
world,
with us
by the
before they
way.
did that,
Worst
but they
visa in the
filed their own fiance visa, and they went through the whole process. They waited, for adjudication of the fiance visa, and the fiance, Canadian citizen, went to their interview, And the consulate just never made a decision on it, never issued a request for any additional evidence, just didn't make a decision. He called, he emailed, he tried to get the consulate to make a decision. He'd been waiting for many months after that interview. And I said, you know, your other option is if you were to marry and you were in the United States, you could adjust status. And then you could be together while you're going through the processing of a marriage-based application, but it entails starting over from scratch, right? Then now you're not doing a fiancé visa application anymore. They understood that. They ended up getting married. They didn't want to wait anymore for the fiancé visa. I think they ended up marrying in Canada, and he came into the United States, and they were, you know, hanging out together, and he called and said, hey, we want to adjust status now. I've been here for a few months, and I still haven't heard anything back from the consulate. We filed it. And the minute we filed it, we heard back from the consulate. They're like, hey, we want to do a second interview. I was like, well, that's not a good sign.
Yeah.
You want to do a second interview? No. So we just ended up continuing on with the adjustment of status, and he was easily approved through USCIS. There wasn't any complicating factors in his case. I'm not sure what the consulate was doing. Maybe his name matched somebody who was on
that's the thing.
List.
You could be clean and they get a hit in a database and you're just stuck.
You're stuck. So anyway, they ended up going through the marriage-based process here in the U.S., and he was easily approved for a green card without issue. And, you know, not trying to do anything wrong. This guy really didn't have anything in his background, but the consulate had, you know, put a roadblock in there.
Yep.
With that fiancé visa. So, and he wasn't eligible for it anyway after he married. So there was nothing he could really do at that point. He would have had to start over with a consular marriage-based process.
In my opinion, if you're Canadian and you can avoid the consulate and possibly adjust. You're dealing with one agency. It's going to be faster. You're going to avoid these complicating factors that can arise at a consulate.
Right. But there are people that have factors in their lives that consular processing is better for.
Maybe they're both living in Canada.
And now the timeline's a little bit better now, right? Yeah. If you're a U.S. citizen, spouse, or family members living with you in Canada.
Waiting.
Yeah,
so
parent, whatever. Yeah.
That works out sometimes too.
For sure. So I think the point is consult with your immigration attorney so that you can get all the factors in line and make the decision that's best for you and your family.
Yeah. And keep in mind, there is some wiggle room with these processes of going, you know, if you started one, you could potentially go switch to the other too. So if you find yourself in the United States and you started through consular processing, but circumstances have changed, you're in the United States and now you want to stay, you could potentially switch to adjustment of status and forego the consular processing route.
A lot of people did that during COVID because they found themselves going to be they were going through the consular processing route, but they found out the borders closing, we're going to be separated. So they ended up switching to adjustment of status. And I like to tell people you can switch one way, but not the other. So if you're in the consular processing process,
you can switch
at certain points, you can switch to adjustment of status. But it's very difficult to do it the other way, like we talked about. There's extra processes involved, months and separation going to be in your future.
So 2 options to consider if you're going through this process. It's very important to understand how each of them would impact you and your family and your situation. You have school, you have work, you have children, whatever it is. These are all complicating factors that you need to talk through to make sure you're making an informed decision. When you're deciding between these two. We deal with Canadians all the time in making these decisions and advising them and clarifying their pathways to help them make the best decision possible for themselves and their family. So if you find yourself in that situation, reach out. We're definitely able to assist you. Hopefully you found this conversation today informative. Thank you for tuning in. And if you haven't already, give us a thumbs up. Please subscribe and tune in next time. Thank you for listening and have a great day.